At this time, though, I'd like to go into the 1960s a little bit more, and that is particularly with the what's going on in Alaska. Right? So, late 1950s, territory of Alaska becomes a state, and it is increasingly becoming important as an oil and gas source. So in the 1960s, we have a lot of people from Oklahoma, including my dad, was in Alaska a lot. The Alaska Native Claims Settlement Act, or ANCSA, is something that occurred in 1971. Alaska Native Claims Settlement Act, ANSA. This was pretty novel. This is something that's really new in Indian affairs. It wouldn't be the last one, but it was really monumental, and I think kind of deserves its own chapter in terms of Indian, the history of United States Indian policy. It's really, really significant. Well, let's look at a little background. We've talked a little about Indian claims, and you remember the Indian Claims Commission gets started in 1946. Indian Claims Commission, ICC, is what we would call a tribunal. It's sort of like a grand jury who hears complaints and attempts to work those out somehow. I didn't talk a whole lot about the Indian Claims Commission. I really ought to a little bit more. It was established in 1946. Now, what period, what era of U.S. Indian policy does this take place in? It actually begins the era of termination and relocation. Right? So it's part of that about face from the Indian Reorganization Act, Indian New Deal. 1946, what's going on here is Congress makes a process, creates a process by which Indian tribes can essentially sue the government, right? Now, if you're suing the United States, or if you're trying to get a claim against the United States, you would go through the United States Court of Claims. But the tribes couldn't do this as sovereign entities. So they were allowed, or actually individuals representing tribes could come forward with these historical claims against the government, saying that, this land was taken for, it was just taken, and it was covered under the Fifth Amendment, and so they were owed land. Or perhaps it wasn't. Perhaps it was an aboriginal title, and there was no Fifth Amendment protection. So the tribe would try to bring a case and say, look, this was a taking, and therefore it's only right for the United States to recompensate, or to compensate the tribe for the land that's been taken. But more commonly, this was a land cession in a treaty, and the amount of compensation for the land which was ceded was far below its actual value. It was even far below the fair market value of the time, which is often the case. Not always. Sometimes Indians got a pretty good deal on their land cessions. Sometimes they even got above market value, fair market value. But more frequently, as you probably can guess, they often got really low prices. And so this was a way that the Indian tribes could lay that claim against the government in the name of justice, right? And the United States government could then settle the claim so that it doesn't have this claim hanging over it. So it is, doing the right thing. And ultimately, though, this was part of the termination era when the federal government is trying to, I usually say tying up loose ends, all right? Trying to get things in order, trying to finish some business to get through something. And so this was basically what the federal government was wanting to do, because once an Indian tribe would settle, then of course they could never bring that same claim against the government again. That's the idea. So it's the federal government's providing us as an opportunity to settle everything out, and after that there's going to be no complaints, all right? So one problem with this process, though, was that it followed the general pattern of American jurisprudence. And that was, we get Team A over here, called the plaintiff, filing a claim against the government. And rather than listening to that claim and trying to work that out, what does the government do? The government has its defense. The government has Group B over here, who are lawyers who are trained to parse out all the details, because you can imagine if somebody's bringing a claim against the government, well, they'd better have evidence, right? And there's probably not a lot of evidence, but there's going to be some. A lot of it's going to be stories and that sort of thing. Well, the idea is that the Indian Claims Commission creates, or the system that the Indian Claims Commission creates, is just like a divorce court or something like that, where you have side A and side B duking it out, right? So there are government lawyers who strongly put the claims of the tribes to the test. They do their very best to prove them wrong, or to prove them, inconsistent, or to disprove, the claim in some way. So, and oftentimes the government lawyers were better than the tribal lawyers, all right? But they were working for the government. So it was, this was not going to be some quick payoff. This was going to be the real thing, the real claim. And this went on until early 1980s, late 70s, I think 78 or something like that. Doesn't matter. But the Claims Commission, just keep in mind, was one facet of the termination era when the federal government was trying to wash its hands, Pontius Pilate, wash its hands of this problem. And it just kept coming. It wouldn't really go away. A lot of these claims cases lasted forever. And here at OSU in the library, we actually have the archive of the Indian Claims Commission available, so you can go into those dockets and see all kinds of cool stuff that the people working for the tribe and against the tribe both were able to dig up. So they dug up a lot of good history in the process. Well, so a claim, remember, a claim is essentially, in this case, it's an attempt to get even, or an attempt to have some sort of sense of justice done. Now, the thing about this, however, the Alaska Native Claims Settlement Act was, in a sense, a preemptive thing. It was I don't want to say a preemptive strike by the government, but maybe in some ways, right? So in Alaska in the 1960s, first thing we need to say is that there were no treaties written up between the United States government and Indian tribes in Alaska. right? Or maybe just a handful, maybe just one hand, a few reservations, but tiny. The vast majority of native peoples in Alaska at the time of Alaska statehood, the Alaska Statehood Act, the state has a very significant number of people who are Inuit, who are people who live in the north, Aleutian Islanders. There weren't a lot of them, but Aleutian Islanders and Native Americans, American Indians. But they didn't have the same legacy that Native peoples in the lower 48 had. So that legacy, of course, was one of manifest destiny and frontier expansion and land treaties and land cessions and awful examples of treaties being broken and that sort of thing. But in Alaska, you have native people still living on the land in the way that they always had. And without recognition of title by the government. So you have a situation of lots of Aboriginal title. Remember that? Lots of Aboriginal title. And then we have the realization that there's a whole lot of petroleum up in the North Slope, and that there probably ought to be a pipeline between the North Slope and Valdez, all the way across Alaska, to move that petroleum to a seaport that can move it out of Alaska. So there are all these sorts of plans that are up in the air in the 1960s for this. Lots of oil exploration going on in Alaska still. And essentially what, if you look, I'll provide you a very short set of reading here, but what was identified was that you've got a lot of people living in Alaska who are Native Americans, Native peoples, who have claim to huge amounts of land, and now we've discovered that they've got claim to those natural resources, but they didn't have established titles. And you can imagine how people would begin to claim land, and how various groups would have disputes in terms of claiming land that was obviously quite valuable for whatever petroleum development, or moving petroleum, or for just access and oil exploration. So the 1971, which was the very same year that Nixon made his pronouncement about self-determination, remember that? Very same year. He made a special address to Congress about his American Indian policy. In 1971, this has been working out for a while, but the Alaska Native Claims Settlement Act was passed in 1971 in Congress. Okay? And this was it was intentionally designed to avoid the same sorts of problems that American Indian treaties had gone through, recognition of American Indian tribes. To this day, we make a distinction between American Indians and Alaska Natives, and this is the reason. Okay? Alaska Natives have a separate form of status, a separate status, and I don't want to say a lesser status, but they have a different type of status. Okay? They don't have a reservation base. They don't have the same kind of land base. Anyway, what the Settlement Act did was it provided a fee title. Okay, it provided fee title to about 40 million acres. Now, there weren't tribes necessarily in Alaska. You have more like settled villages and small groups of people, not big organized political bodies. But as part of a settlement to sort of clear everything up, in the same way that an Indian Claims Commission settlement would clear things up and make boundaries distinct, is that in addition to that 40 million acres of land designated to different Alaska Native villages, and there are over 200 of them today. So we got close to 500 American Indian tribes recognized by the federal government. So around 500 federally recognized tribes, and over 200 Alaska Native villages. Okay, and those are small locations, locales that received land. Okay, they also received a payment of $462 million. $462.5 million. And, okay, and this was actually, these are placed into investments. And each one of these Alaska Native villages are not tribes, but they're created as corporations. They're actually called Alaska Native Village Corporations. You don't see that on the census forms and that sort of thing. But Alaska Native Village Corporations. They are essentially businesses or corporate bodies, legally corporate bodies. So they're, incorporated. But this is the big one. Yeah, $462.5 million. Not a lot. 1971, it was probably still a lot. But this is the big one. All of those entities share a 2% royalty on all mineral development, oil production. To $500 million. Let's see.
The tribes receive 2.2% of royalty.
They're distributed 2% of the royalty. And in exchange for this, they give up basically Aboriginal claim. So this is to compensate them for anything like a treaty. So this is they forfeit Aboriginal title. Right? I need to say original Indian title. Okay. So, and this is a very complex law. It's hard to just introduce it. What this did was it created 13 regional corporations. So Alaska's a huge state, but it grouped villages by region, and then within each of those regions you have these village corporations. So a village corporation is basically kind of like the actual traditional group of people in settlement. And those Alaska Native Village corporations have basically their own political autonomy within their area. They do things the way they want to do things. But there is no reservation land. There's no public land held in trust for the Indian tribes. Okay? Which exempts them from having oversight by the Bureau of Indian Affairs. So no reservations and no Bureau of Indian Affairs. However, by extinguishing all Aboriginal or original Indian title, Native Alaskans can never contest the United States for a claim. They've settled it ahead of time. So this stripped Alaska Natives of federal protections of tribal sovereignty and tribal land. But they've got protection. I'm probably lecturing off the camera here. They've got protection through corporate law. Okay, they're not bound to the same body of Indian law that everybody else we've talked about so far does. Okay, it's a little bit neater and less problematic for the most part. No Bureau of Indian Affairs, that's a plus. Now later on, Alaska Natives would gain more sovereignty, as you want to call, if you want to call it that, similar to American Indian tribes. But the big difference is that there are no reservations, and the tribal entity is not a tribe or a band or whatever. It's a corporation, and it's created in 1971. It's or early 70s. They're created as legal entities by the United States. Okay. So, is this a good thing or a bad thing? The Alaska Natives haven't revolted. For the most part, I think you can say they did it right. And you'll read more about this, and we'll get more into it. It's really actually very interesting when it comes down to natural resources and who gets what. And it does not mean that there are not problems that arise. There are not disputes that arise. We'll actually read about some issues having to do with mining and fishing and the rights of Native peoples in these village corporations to utilize natural resources from the indigenous standpoint. But in 1971, after nearly 2 centuries of Indian policy and mistakes, the federal government had the foresight to approach it in a way that might be equitable from the start. Okay, now I'll probably get all kinds of hate mail for that, but we'll see. Next thing. Oh yeah, this is the finales. Here we've got in I think I've already told you about the part of the termination era is you've got this idea of what is Indian country and that sort of thing. So in 1948, the United States Congress actually defined Indian country in 1948. It's defined as all land within the limits of any Indian reservation. I'll post this, you can see it later. All land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent, and including rights of way running through the reservation. Okay? That's one type of Indian country. Reservation land is all they're really saying. And reservation land, even within the boundaries of a reservation where someone has received fee title, fee land, okay? Even that fee land is considered Indian country in some regards, in terms of jurisdiction and that sort of rights of way, okay, also. Roads. B, Indian country is also defined as all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. So we don't have any well, we do have some protectorates, but this is an interesting term, the dependent Indian community. Right? What does that really mean, dependent Indian community. It's referring to the political entities, right, of these. Remember that American Indian law is always about the tribe, not about individual Indians. Most everything we've seen is the United States federal government dealing with the tribe. So dependent Indian communities are tribes that may be totally landless. So, or not even, or perhaps not recognized, okay? But they call themselves groups. Perhaps they'll be recognized, or they may have been tribes that were recognized by states, but were not recognized by the federal government. So they're sort of the exceptions to the rule. And then finally, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same. So any Indian allotment that has a restriction on its sale or has not received a patent yet, all of those are considered Indian country, even if the reservation is long gone. So that includes a lot of Oklahoma land. You know, a lot of Oklahoma allotments were made, and then the territory or reservation, if it was a reservation, was formally extinguished and gone with land opening or whatever. But that Indian allotment, if it's restricted, still has the same status as a reservation. Now the question is, you might, if you've listened to that, or if you read it later, you'll say there's some contradictions in that, right? And there are. So what's the status of an allotment where there's fee title? The reservation still exists, but that's not Indian land, right? That's fee land. How is it covered by the authority of the tribe? That's a good question. And that's when things get really complicated, because, and we'll see this later, but eventually what happens is the federal courts would create tests. They would create legal tests to determine whether or not a reservation had been either diminished or completely obliterated. In other words, if it's been sort of diluted to the point to where it really shouldn't have a lot of autonomy, or it may have been completely disestablished, which is completely obliterated and it doesn't exist anymore. This was recently the case with the Osage Reservation, which has been found to be disestablished, even though it's still on the roadmap. Okay, but it's a matter of splitting hairs for various reasons, but this is what we have to recognize today as Indian country. So there's those are three categories, but within each one of those categories there are a lot of sort of weird possibilities with that. All right, let me see if there's, in terms of jurisdiction, however, okay, there are differences in criminal and civil jurisdiction depending on your location. Okay, so we've talked a little bit about Public Law 280, and so we have Public Law 280 states that have received from Congress criminal authority, civil authority over Indian country within their boundaries. Remember what those states were?
Cal, Minnesota, Nebraska, Oregon, Wisconsin. Is that it?
Wisconsin?
Yeah.
California? Nebraska? Minnesota? Oregon. Okay. So those are some exceptions to that. If there are exceptions for other laws, then your definition of Indian country gets kind of turned around again. So right. Well, we can get into that a little bit later when we start talking about taxation. Taxation makes this is the reason we can parse all these definitions out. Or when it comes to criminal law, I'll give you a terrible example. When there is a major crime or say a murder of some sort, what matters is, in terms of the jurisdiction of the law enforcement agency, if you're speeding out on the turnpike or out on I-35 and you're just out in rural Logan County, all right, you get pulled over by who? Oklahoma State Trooper, right? Highway Patrol. Highway Patrol, as well as the county sheriff, as well as Oklahoma State Security, Oklahoma State University Police Department. Those are all state entities, right? They're all working for the state of Oklahoma, so they're similar. The county, of course, has its jurisdiction just for the county, but it's still a state entity. Municipality, on the other hand, is different. So even though they share a lot of, they may cooperate, the jurisdiction is going to be of the state if you're outside of a town somewhere. But what I'm trying to get at is what really matters as to the jurisdiction. What matters? Location, right? The location of the crime or location of the misdemeanor, the location of the violation, whatever it was. That's what matters. What if somebody from Kansas comes speeding down the I-35 and can the Oklahoma State Trooper pull them over? Of course. Absolutely. How about a Native American with an Indian license plate? Can they get pulled over for speeding? Yeah, absolutely. Okay. So it doesn't matter as to the identity when it's not Indian country. It matters. What matters is the location for jurisdiction. Jurisdiction of whatever court. Okay. Yeah.
What is the purpose of the Indian license plates?
We'll get into that. We'll cover that pretty closely. But it's largely a taxation issue and kind of a sovereignty issue. Now, if you are a Native American, let's say you are Navajo and you're speeding in the Navajo Nation, and you get pulled over by a Navajo patrol or Navajo policeman for speeding, and you've got an open container of alcohol in your car within reach. All right. Big trouble, right? So what's the jurisdiction? Most of the time, the jurisdiction would be the tribal courts, but only for the Indian, okay? So here's what is one of the things that makes me most fascinated about the whole subject of this course, and that is American Indians are really the only group in the United States who are subject not only to territorial political geography or sovereignty or authority, but they're also subject to jurisdiction based on who they are. All right? But that really only applies in Indian country by American Indian authorities. Okay? Now, if you go speeding through the Navajo Nation and you're not a Navajo and you're not an American Indian, and you get pulled over for open container or whatever, can they do that? That's a good question. All right, interesting question. Because there are, the reservation still has counties, and the counties still have their own sheriffs. Right? So we get into these sticky sorts of situations. I'll give you another example. When I was a small kid, my stepfather was for 31 years, he was a special agent for the Federal Bureau of Investigation, FBI. who's an FBI agent. And his area of work, his territory, was for the most part northeast, north central Oklahoma. And I remember one night, you know, we were probably sitting around watching Barnaby Jones or Cannon or one of those crime shows, right, on television in the 70s. But I remember him getting this phone call, and he's on the phone, and you know, he's on the phone for a long time talking to obviously a sheriff somewhere, right? And so I kind of eavesdropped a little bit. I thought, this is interesting. I want to hear about this. You know, I didn't know what was going on. But I listened, and after a while I asked him about it. And what had happened was there was a murder. There had been a very complicated issue up at Red Rock. Red Rock is Noble County, Otoe, Missouri tribal area. And up at Red Rock, there's a lot of HUD housing, you know, what we call Indian housing. It's a sort of a, you know, small houses that were built in the late 70s, early 80s. And most of the, you know, tribal people are living in those. And it's you know, it's an impoverished area, at least it was. This was way before casinos. Not that that's helped that much. But, anyway, the situation went something like this, if I can recall. Two American Indian fellows were partying, you know, drinking, and then they supposedly moved on to harder stuff. Basically, they were sniffing gasoline. Don't do that. Sniffing gasoline and getting kind of really blown out of their minds, and then they got into an argument. All right. So you know, think about your roommates and stuff. Don't sniff gasoline. They got in an argument. They got in a fight, and they lived next. You know, they're pretty close to one another. Like one was, you know, they were fighting or something, and the guy started walking down the road. Another guy got his rifle, picked him off, killed him. And the problem was that the perpetrator, you know, the alleged shooter, had apparently shot from Indian country. So the crime was acted within Indian country. But when he shot the guy, he shot him like off on the highway, and he fell dead outside of Indian country. Okay. So here was the sheriff of Noble County saying, it's not my jurisdiction, you know. And I don't think, and I don't think the tribal police maybe even existed yet, but if they did, they were confused too. But the county sheriff was really confused. He said, you know, it's all within my jurisdiction, but the shooter was on Indian country, and I don't know how to handle this, so I think it's a federal case. Which my stepfather, of course, was saying, no, it's not a federal case. It's not a federal case. Yeah, it took place in the county, you know. So they're arguing over the jurisdiction because, frankly, nobody wanted to take it. You know, it's too problematic. Because if you screw up, if you make the wrong choice and you're collecting evidence or something, and if you're collecting evidence and you don't have the particular jurisdiction to collect the evidence, you're gonna screw up the whole case. You're gonna screw up the prosecution, right? So there are these weird caveats and especially in Oklahoma, where you have what's called checkerboarded Indian country all over the place. Okay. So anyway, we're going to talk about some of the ways that is worked out these days, and that's actually pretty interesting. But you know, that's for more to come. Well, anyway, I think that's probably enough.